Okay. Welcome, everyone, and thanks so much for joining us today. I'm Sue Ostoff, and I'm with the National Clearinghouse for the Defense of Battered Women here in Philadelphia, lovely Philadelphia, I may add, and I'll be your host for today's webinar. Before we begin the presentation, I need to go over some logistics. And those of you who have participated in these webinars through iLink before, you know the drill. So you might want to go get a cup of coffee or tea or whatever. But for those of you who are new, or if you're having technical difficulties, you'll probably really want to hear this. If you're disconnected from the webinar, if you get disconnected from the webinar at any time, just go back to that original email that came out this morning, early morning, and click on the link again to log back in. And if you continue to have problems, call iLink support. And they got our presenter on today, so they can help you out. And it's 800-799-4510. That's iLink support. And Sandine, if you could put that in the chat box, please, that would be great. It's 800-799-4510. And thank you, Sandine. So there in the bottom left-hand corner, you'll see of your screen, you'll see the public chat box. And Sandine, if you could give the information about people who are having volume problems, please, that would be helpful. So down in the chat box, in the very bottom box down there, if you put your cursor in there and then you click on it, you can type a message and then you can hit return and it will post it to the public chat. So why don't we try it now? Some of you have already done that and told us about the weather, where you are. But if you can tell us where you're calling in from, and if there's more than one of you at your location, if you can let us know how many of you are there, that would be really helpful. So why don't we try out the chat box? Just thanks, Aaron, Tenley. Great. And thank you. If there's more than one of you, if you can let us know, that's really helpful. Great. So people are seeing it, where the chat box is. Great. And you're seeing that people are calling in from all around the country. Terrific. Thank you so much. So as you probably know, all the participants are muted, and that's why we'll use the chat feature for questions. So if you have questions when Chris is speaking, when our presenter is speaking, type your question down there, and we'll capture those. And to the extent we have time at the end, Sandine will pose these questions to Chris. And we'll do the best we can to get to as many questions as possible. So you can just put your questions in during the webinar down in that box. And if you're having technical problems, you can private chat me. Go to that. I think you can. We're having some issues with chat. You can just put it in the public chat if the private chat doesn't work. Or you call iLink again. And Sandine, would you put the number back in? Mm-hmm. Thanks. And if you happen to be only on the audio portion today, that you're not signed in to the iLink system, you can email me directly with questions at sueo@ncdbw.org. They're terrible initials to say on the phone. So it's National Clearinghouse Defense Battered Women.org. Those initials, NCDBW, and I'll try to get back to you. I'll have one of my coworkers get back to you. We are recording this webinar today, and you'll be able to access it on our website, hopefully within about a week. And our website is www.ncdbw.org. About a half an hour after the webinar concludes, I'll send out an email to all of you, and it will confirm a little confirmation of your attendance. It will also include information about our website if you missed it, and it will include a link to a very brief survey. It's a little evaluation and a little feedback survey, and really you can probably finish it in less than 2 minutes. And we'd really appreciate it if you took the time to do it. It really helps us and it helps the presenter for future webinars. So I do want to thank the Office on Violence Against Women for the support of the National Clearinghouse's, what I think is a very exciting project on expert witnesses, and also the support of their work of Equitas. you can read the fair use clause. Can you tell it's an organization of lawyers? And also to acknowledge that the Pennsylvania Coalition Against Rape and the National Sexual Violence Resource Center with Joyce Lupima, I hope I'm saying her name right, has also participated and needs to be acknowledged. So thank you. So we also want to find out who's on this. Right now there's about 105 of you. And so we're going to ask you to answer a few questions. And what we want you to do is actually answer the questions directly on the screen for those of you who are signed in to the webinar through iLink. So let's see if I can get these up today. Sometimes they work and sometimes they don't. We're having one of those days. Now I have multiple copies and none of which are working. I'm sorry about the technical difficulties. iLink has done a recent, well, wait a sec. iLink has done a recent upgrade and it hasn't worked out very well. It's still working out bugs. But here we go. We did get the questions up. I hope those of you who are signed in can see them on your screen. So we want to know how you would describe your profession. So if you're a community-based advocate, for example, if you would click that dot that's immediately to the left. Oops. Did it just go away?
Mine just came up, Sue.
So did mine.
Okay. Mine just went away. Okay. Is it still up?
It sure
Yes.
is.
Okay, great. So if you can just click onto that dot, the appropriate dot, and if you answer other, then if you would please put what your profession is over into the chat box. That would be terrific. The same thing about your participation as an expert. So we're trying to find out whether or not you have already participated as an expert, and we use that word to indicate that you may have been asked to participate in a case and ended up not testifying. So we're saying if you testified or worked on a case but ended up not testifying, and no, you haven't, so it's yes or no. And for those of you who know, if you are also interested in participating as an expert in the future, if you could indicate that there, that would be terrific. So, and then we want to know who's an OVW grantee and what kind. And again, if you can answer directly by selecting one of those dots, and if you're an OVW grantee that's not listed there, if you could please put that in the chat box, that would be great. Okay, so let me just get some of these results up. Are you seeing those, the percentages?
Not yet, Sue O. And I also want to say when you're indicating your OVW grant program, you may have to scroll down to see the rest of that question.
Thank you, Cindy.
You're welcome.
Because it's off the screen.
Yep.
There are 4 questions we're asking you to answer. Are the percentages coming up now?
Not on my screen.
So what I'm seeing on mine is that
there they are.
Okay, so you see that there are 22%, almost a quarter community-based advocates, and about 14% are prosecutors. And then you can see and almost as many clinicians, social workers, and therapists. Okay, so great. And we have 20% of the people who are on, or at least who answered, have testified or participated in a case as an expert. Thank you very much for doing that. That's really helpful. Now let's see if we can get back to the PowerPoint. We did. Is that up on yours, Cindine and Chris?
Not yet.
Okay, so there's a little delay here, so sorry about that.
It's funny that there's lag time when I'm 3 offices down from you.
Yeah. So for those of you who just joined, again, I'm Sue Osthoff with the National Clearinghouse for the Defense of Battered Women, and I really want to welcome all of you, and thank you for joining us in this webinar. This is the 5th in our series of webinars about expert witnesses in cases that involve survivors of battering, sexual assault, and other forms of trauma. And if you missed the first 4, any of the first 4, or all of them, recordings that actually pull up the copies of the PowerPoint, once you start listening to it, are posted on our website, so you can get them there. And Cindine, if you'd put the website in the, thank you, in the chat box, that's great. And once you get to the, it says it, once you get to the website, go to the resources. Just a quick heads up, we have posted PDF versions of the PowerPoint on our Google Docs site if you want to save it and or print it, because you can't do that from iLink. You'll also find an article from 2007 by Jennifer Long titled Introducing Expert Testimony to Explain Victim Behavior in Sexual and Domestic Violence Prosecutions, and Cindine posted that there. Just to reiterate, you do not need a Gmail account or a password to get into the Google Docs site. Some people have had troubles. Cindine, if you can, again, I guess you did post that information about some of the hints that we've had that have helped get people in. If you do get stuck, there's information. You'll have information in your follow-up email about where to email us, and we can send you copies of the PowerPoints if you have trouble. I mentioned earlier that the participants are muted, and so what we'll do if you have questions is take those questions in the chat box in the lower left-hand corner. Okay, so finally, as you know, today's webinar is titled Prosecutors' Use of Expert Testimony to Explain Victim Behavior in Domestic and Sexual Assault Cases. And we are extraordinarily lucky to have such a great and experienced presenter today, and that's Chris Mallios. And so you'll see his picture here and on the side there. I know the type here is really small, but we wanted to try to move along as quickly as possible. But I also want to alert you that his full bio, which is much more extensive than this, is actually up on Google Docs as well. So you might want to take a look at that so you can get a more of a sense of all of the experiences that Chris has had. And again, if you want to post the link, Cindine, that would be great. I think a number of you on this webinar do know Chris or know of Chris, and he's been an attorney advisor at Equitas, which is the prosecutor's resource on violence against women, for about 4 years now. And in that capacity, he just travels all around the country, training prosecutors and others about a huge range of issues related to violence against women. And he develops all sorts of resources and training materials, and he provides consultation and technical assistance for prosecutors and other allied professionals around the country. Chris is a fellow Philadelphian, and I got to know him when he was working at the Philadelphia District Attorney's Office Family Violence and Sexual Assault Unit, first as a trial attorney, and then he became chief of the unit. And in that position, he prosecuted and supervised the prosecution of literally thousands of cases involving domestic violence, sexual assault, and child physical and sexual abuse. After 10 years in that unit, he then worked for 3 more years at the Philadelphia District Attorney's Office as a prosecutor lobbyist in their legislative unit. And since he's been working at Equitas for the last 4 years, he's continued to be very active in the Philadelphia domestic violence and sexual assault communities, and continues to provide trainings here to prosecutors, and he's taught trial advocacy at one of our law schools, Temple Law School here, and he's currently an adjunct professor at the University of Pennsylvania in the School of Social Policy and Practice, which used to be called the School of Social Work. And last, and certainly not least in my opinion, he was not only a law clerk in one of his previous jobs, he was also a criminal defense attorney. And besides all of that truly amazing experience, I happen to also know that Chris is also a really excellent cook. So that's lucky me for getting to live in the same town he does. So he is quite the talented guy. And the truth of the matter is I really do learn so much from Chris every chance I get to talk with him. So it's really my honor and privilege to get to introduce him today. There's a ton to say, so I want to turn it over to him. And just a reminder, if you're having trouble connecting, try calling iLink support at 800-799-4510. Cindine, maybe you could put that back in. Or you could call us at the National Clearinghouse at 215-351-0010. But you'll probably get better technical support from iLink directly. So thank you all for joining us and for your patience getting through the tech stuff and the introductions. And Chris, thank you so much for all your amazing work and for your willingness to share it with all of us today. So,
It's my pleasure. Thanks for having me. So let's briefly go over the learning objectives for this webinar. It's our intent that the participants at the conclusion of this presentation will be able to recognize some of the victim behaviors that may be but may need some explanation at trial because judges and juries don't understand some of the very common victim behaviors in domestic violence and sexual assault cases. It's also important that participants realize that sometimes we have personal biases and preconceived notions about these types of crimes and how victims act or should act. And when the responders have expectations that are not really based on reality, but based sometimes on popular culture and myths and misconceptions, that can really interfere with the response that victims get. We also want our participants to be able to educate judges and juries about victim behaviors and dispel myths, and be able to work with experts to prepare cases for trial, and also to apply necessary law to be able to introduce expert testimony at trial. Those last 3 bullet points really apply to the practitioners in the courtrooms, prosecutors primarily, although there's great information in here for advocates, for experts, and for would-be experts who may be thinking about offering this type of testimony in the courtroom. One of the terms we like to use when we're talking about cases involving violence against women, and I do want to start out by saying that this really is gender neutral in domestic violence cases and in sexual assault cases. The vast majority of the victims are women, and the perpetrators tend to be men, but the legal principles that apply are absolutely gender neutral and sex neutral, and it's important to keep that in mind. But when we talk about offender-focused prosecution, what we're talking about is the prosecution continually keeping the focus of the trial, the focus of the prosecution on the criminal conduct of the offender. What we see so often is that defense attorneys, for strategic reasons, try and turn the trial around, try and put on trial the victim's behavior, the decisions that the victim made, perhaps the victim's use of alcohol or drugs or some other unlawful conduct, usually petty crimes committed by victims. That's not what these cases are about. These cases are about the crimes that have been charged, and the crimes that have been charged are crimes of sexual violence, crimes of domestic violence. And what this strategy of trying to put the victim on trial can be an effective one, because when victim behaviors do not comport with judges and juries' perceptions of how victims should act, how the quote-unquote real victim would act, that really can go a long way toward advancing the defense theory that the victim is not credible and that the offender therefore should not be held accountable. So offender-focused prosecution, it's a very important term when we're working on these cases. Although the prosecution needs to be offender-focused, it's important to realize that crimes do happen in the context of a victim's life. They happen in the context of their relationship with the offender, the victim's culture, their race, their ethnicity, their ethnic background, their country of origin, their language proficiency. All of these things affect the way a victim is going to act and the way a victim is going to respond to violence or respond to the trauma of violence. It's also important to realize that victims' sense of self also impacts how they respond to the trauma of domestic or sexual violence. Are they blaming themselves? Do they not see what happened to them as a crime? Does the victim also accept some of the myths and misperceptions about rape and domestic violence? Do they think it's only rape if it's a stranger and not realize that forced sex, even in the context of a marriage or an intimate relationship, is violence and is a crime? And also the audience. The audience affects how a victim responds to the trauma of abuse and violence. Who is looking at the victim? Victims may act certain ways for other people around them, maybe to conceal what has happened to them, maybe to not show the offender how badly they've been hurt. There are so many different reasons. And for all of these reasons, there's a wide range of victim behaviors in response to the trauma of violence and the trauma of abuse. There's no one way for a victim to act, and what we see is the victims act in a lot of different ways, but frequently judges and juries have in their minds an idea of how a victim would act, and sometimes those ideas interfere with a proper criminal justice response for victims. Some of the reactions that are often difficult for lay people who have not been trained in these areas to understand are, well, the first one, sure, staying in an abusive relationship, right? Why didn't she leave? If this had really happened, she would have left. And that mindset, that myth about abuse is just so pervasive. And a lot of times it just boils down to jurors or judges thinking in their minds, well, if that happened to me, I would have left. And because she didn't leave, I don't find her credible. That's a very, very common reaction, and it's a very, very often misunderstood reaction. If the victim chooses not to fight back, if the victim does fight back, both of those can be used against the victim to discredit them. Most victims of abuse, most victims of sexual assault never report their abuse to law enforcement. And of those that do, there's often a delay. That opens a door for defense arguments that if she were a real victim, she would have called the police right away. And again, it really, it's not based on fact, but it's based sometimes on popular culture's representations of how victims act on TV and movies. Victims who have continued contact with the offender, whether it's an intimate partner or a former intimate partner or even merely an acquaintance. This is a common behavior that we see in abuse cases and sexual assault cases that's often very difficult for judges and juries to understand. Victims who decide not to cooperate with the law enforcement investigation or not to cooperate with the prosecution, also very common behaviors, as is recantation. Recantation is just a part of doing this work. The longer you do it, the more of these cases you see where victims recant. Frequently, that's a victim's way of just saying, I don't want to go forward with this case anymore. I don't want to testify. I don't want to talk to strangers about embarrassing facts anymore. And it's a very, very common reaction. When a victim does not fight back, when the victim does not yell, we call that earnest resistance. There are lots of different ways for a victim to resist. And when a victim does not fight back, does not punch, in the case of a sexual assault, doesn't scream, doesn't knee the offender in the groin, all these things that people like to think they would do if they were being assaulted, when victims don't do that, again, it opens the door for defense arguments that the victim is not telling the truth because a real victim would have acted a certain way. I talked about delayed reporting, but there's so much research on this about underreporting of domestic violence and sexual assault cases, the small number of victims who report, and those that do almost always delay, although they'll frequently disclose to a friend or a family member before they disclose to law enforcement. And that can sometimes be important in these cases because that person to whom the initial disclosure is made may be a witness in the case. Non-victim-like behavior after a crime. Sometimes a victim will act like nothing happened after they've been victimized. They'll put on makeup to cover their injuries. They'll return to the party after being sexually assaulted in a room upstairs. They try and act normal. They try and return to a sense of normalcy and not show anyone what happened to them, how badly they were hurt. There are lots of reasons for this, but it's very, very common. Why does that happen? Well, how the victim is experiencing the assault is going to affect how they act afterward. Who the person is who assaulted them is going to affect them, and the way the victim is judging their own behavior is also going to affect how someone acts. If someone's blaming themselves, that may be a reason for them to keep it private, to keep it a secret and not tell anyone. There are so many factors that go into this, but these are really three that are some of the big groupings that affect how victims act after assault of crimes. Sometimes, we talk a lot about some of the myths and misconceptions surrounding sexual assault and domestic violence, and it can't be stressed enough that so often victims themselves also internalize some of these myths and misconceptions. They don't see what happened to them as domestic violence. They don't see what happened to them as a crime. They may not think that it's appropriate to talk to anyone about what happened, whether it's law enforcement, whether it's reaching out to a rape crisis center or domestic violence shelter or a social service agency. So often the victims themselves really internalize these things, and that also contributes to low reporting rates and some of the victim behaviors that are sometimes very difficult for lay people to understand. It's so important to realize that we're talking here about traumatic crimes, and trauma affects everyone differently. Some of the causes of trauma that we know of are extreme fear or terror, betrayal, the type of violent blitz or surprise assaults, sometimes just severe blame and shame, blaming yourself and being so ashamed of what happened. And when there's a disclosure and there's a bad reaction to the disclosure, telling a friend, telling a family member, telling law enforcement, and not being believed or being accused of doing something wrong can really contribute to trauma, as well as lack of support. Whether someone has friends, family members, or whether they're connected to social service agencies or victim advocacy services, that the lack of support can make the trauma from any of these crimes worse than it is. And trauma can have long-term effects and it can have short-term effects. And the impact of the trauma on the victim will most definitely impact how willing a victim is to participate in the prosecution, how able a victim is to go forward with an investigation and a prosecution. So it's really important to keep that in mind. Sometimes we get angry when our victim doesn't want to cooperate, and we don't understand why they don't want to cooperate. You see serious crimes, and sometimes it's really the impact of trauma that is having an intense effect on the victim and their ability to even talk about this, let alone to cooperate in a law enforcement or criminal prosecution. There are also cognitive reactions to trauma that can really affect brain functioning, confusion, disorientation, dreams, nightmares, difficulty sleeping. Sometimes people question their whole lives, their spiritual beliefs, their relationships. These can really be profoundly impactful crimes for victims, and it's so important to realize that. Some victims have outward behaviors that are easy to see. Crying, anger, sometimes that anger may be directed at the responders, at the police, at the prosecutor, sometimes even at the advocates who are trying to help the victim. This last bullet point, hypervigilance, I've seen this again and again and again. I can think of one victim who still calls me. Her offender's been in jail for probably about 15 years, and she still calls me and says, I think I saw him. Can you check and make sure he's still in? And he is still in. But that type of thing is not uncommon. So the behaviors that we see in victims are very, very often caused by the abuse committed by the offender. And when victims believe these myths, that will also contribute to how they're acting. But it's just so important that we understand as responders the impact of trauma, what causes it, what doesn't cause it, and be able to talk about it. Because when you're talking about traumatic crimes, when you're talking about behavior induced by trauma, it's so important that we be able to educate judges and juries and explain behaviors that they may not understand. So how do we explain these behaviors? Because the other side, the defense strategy, is often geared toward blaming victims. And it's the job of the prosecution to keep that prosecution focused on the offender, although there's going to have to be some explanation. The jury's going to have to be given a factual basis to understand how the victim acted, why the victim acted certain ways. Sometimes the victim is able to explain those things, but sometimes we need outside experts. And why is it necessary? Well, there's been a lot of research on this, and there have been a lot of cases on this. And the truth is that violence, intimate partner violence, sexual violence, family violence is different from other types of violence. This is a case out of California, People versus Brown, that really went into some great detail talking about the difference between domestic violence and other forms of violence. If people who are making decisions about these cases, judges and juries, don't have any firsthand experience with domestic violence, then they may not understand, unless they're educated, why victims act in a certain way. The thought of being in love with someone who committed a violent crime against you is a hard concept for a lot of people to understand. And sometimes the behaviors that go along with that affection, with that dependence on the abuser, the ties, the strong emotional bonds that they talked about in this case are just really important to understand when understanding these cases. This case also dealt with a recantation, a prosecutor who went forward even after a recantation, and the court found that expert testimony about the dynamics of abuse would be very important to understand the dynamics of the recantation. This same case noted that prosecutors frequently go forward in cases without the cooperation of the victim, doing an evidence-based prosecution. And when that happens, when a victim refuses to testify, is not able to testify, or is not there for any reason, it's so important that the judge or jury be educated about these dynamics so that they can understand what's going on, what a typical, there I go using that word typical, what a common reason is for that type of behavior. There's also been some great research about rape myth acceptance. And rape and the dynamics of rape and sexual violence have been studied since the 70s, and there are lots of journal articles out there. The problem is that most lay people don't read journal articles. So although the research is out there, the myths continue to persist. And a lot of times those myths are fueled by TV, they're fueled by movies, and they're just fueled by old ingrained attitudes, frequently sexist attitudes, because so often we're dealing with crimes against women, and for so many years, for decades, centuries really, the responders in the criminal justice system were predominantly male. So a lot of the attitudes, a lot of the jurisprudence in this area that evolved in the earlier part of our country are just so sadly outdated. Yet there are still laws that are based on some of those things. This is a great case from the military courts where the court recognized that expert testimony to explain victim behavior in a sexual abuse case may be necessary because the behavior would seem counterintuitive to the jury. This is a 1996 case. It was a court-martial in a child sexual abuse case, and the court noted that the military courts going back to the 1980s and 1990s have been allowing this type of testimony, expert testimony, to explain common victim behaviors. It's interesting that this is one area where military prosecutors have been very, very progressive and have been aggressively using this type of testimony to help win trials and educate the members of their panels in the military juries. This Rinning case or Reining case really acknowledges that the defense will try to use behaviors that seem counterintuitive to the jury to undermine the victim's credibility. And the court acknowledged on a challenge on appeal that this type of testimony, expert testimony to explain this behavior, will help counteract some of those defense arguments that are not based on the facts and the truth about how victims act, but again based on myths and misconceptions about how victims act. So when you're ready to work with an expert, and these are some great practice tips, both for prosecutors and also for experts who are thinking about giving this type of testimony, it's so important that the expert have an updated CV, and that the CV include all of the training and experience that the witness has. This webinar should be included on that CV. Any ongoing education, any seminars that have been attended, webinars, national trainings, regional trainings, in-house trainings. Every time that a training is attended, it should be documented on the CV. Every time a witness testifies, it should be documented on the CV. And you need to be prepared as a witness to hand that over to the prosecutor or the defense attorney or whoever sends you a subpoena, and be aware of everything that you have in there. The first time you testify, it's a lot of work because you're getting this together, and this may be a much more detailed CV than you would use if you were applying for a job. It might be the same, but you really want to make sure that you list everything in there that's going to support a finding that you're an expert, because there's going to be someone on the other side perhaps arguing that you're not an expert. And this can be a very adversarial proceeding just to get a witness qualified. So you need to give the prosecutor all of the ammo that you can by making sure you have everything in the CV. It's so important that experts and prosecutors talk to each other before the trial. The defense may need to speak to the expert. There's nothing wrong with an expert talking to the defense attorney or sitting down with the defense attorney and the prosecutor. The truth is the truth, and common victim behaviors are common victim behaviors. It doesn't matter who's asking the question. If someone's going to be convicted of a crime, they're entitled to due process, and their attorney is entitled to prepare. We hear again and again from people who are being called as experts in criminal cases, whether they're experts in victim behavior or sexual assault nurse examiners, that so often prosecutors just assume that the expert and the prosecutor are on the same page, and they don't feel a need to prepare them. Sometimes they feel that they don't have time to prepare them, and what we see are prosecutors being put on the stand sometimes with little or no preparation. That's never a good sign, and it rarely works out well. It's important to think about what behavior you need to address as a prosecutor. What factors, what behaviors is the defense going to hammer and try and argue at trial to argue that the victim is not credible, and then how do you address those behaviors? Some of the terms we like to use are victim behavior and victim responses to trauma. We're talking here about an expert witness coming in and talking generally about common victim behaviors. We're not talking about an expert sitting down with the victim, interviewing the victim, and giving a diagnosis. We're not talking about an expert reading the police reports and coming up with an opinion about what was going on in that victim's mind and then going into court and explaining that. That's not what we're doing. We're talking about general knowledge. We sometimes call these experts blind experts because they do not need to know the specific facts of how the victim acted or the specific facts of the case. They're speaking very generally about very common things. Some of the terms that we do not want to use when we're calling an expert or when we're testifying, things like post-traumatic stress disorder, rape trauma syndrome, or talking specifically about the neurobiology of trauma. And we're going to talk about some of the reasons for this in the next few slides. PTSD is probably something we should not be using when testifying as an expert or when calling an expert in these cases. The reason for that is it is a diagnosis under the DSM-5, and you may have a victim who doesn't meet the diagnostic criteria for post-traumatic stress disorder. Also, that disorder may not explain all of the victim's behaviors. One of the characteristics of PTSD is that it has to persist for 30 days in order for there to be a diagnosis. And you may be using it to explain behavior that happened hours after the incident or a day or two after the incident, and therefore this diagnosis may not apply to some of the behaviors that you're trying to explain. But remember, this type of diagnosis, one of the difficulties with it is it's not general background information about how victims commonly act, and it tends to be a diagnosis that's very specific to a person. And when we get into those type of diagnoses, that may have the effect of opening the door to the defense asking to see all of the victim's counseling records, or that the defense may want their own expert to examine the victim to determine whether they have this disorder or this diagnosis, and that could be very difficult for the victim. It could really result in a mini trial on this issue and could be even a further invasion of the victim's privacy. Battered women's syndrome or battered person syndrome, again, is something that shouldn't be used. It's not a diagnosis in the DSM-5, right? You don't want to use it if it is a diagnosis. You don't want to use it if it's not a diagnosis. But it really sounds like the victim has an illness, right? A syndrome. You may have victim behaviors that are caused by other factors. It's so important that you realize that this type of witness, when called by a prosecutor, is very different than a defense attorney calling an expert regarding battered windman syndrome to as a defense or for a diminished capacity defense or some other argument that the victim should not be culpable for using violence. That's very, very different than this type of testimony. This type of testimony is general, it's background, it's testimony about common victim behaviors, not how this victim acted in a particular case. Rape trauma syndrome is another term that probably should not be used in these cases. Again, this is not a diagnosis. It suggests that the victim may be ill. Again, that word syndrome could lead to an inference that the victim has an illness. Also, you could have symptoms caused by other factors. And again, we don't want this type of syndrome being attributed to the victim and also opening the door to the defense asking for an examination of the victim or asking to use the or asking to see the victim's counseling records or mental health records. The phrase neurobiology of trauma is an important one to know. It's not necessarily something we want to have our expert talk about, but it's important to realize that traumatic memory is different from ordinary memory. There has been research on this that shows that there are chemical changes that occur in the brain, and there is also memory loss attributed to the way the brain records traumatic memory. It's very common for victims not to remember certain parts of traumatic assaults. It's very common for victims to sometimes remember the facts of assaults, perhaps not in chronological order, but remembering sometimes the most impactful things first or last, and sometimes the statements of witnesses may seem somewhat inconsistent because they're not always in the same chronological order. This is all explainable if you understand the neurobiology of trauma and understand traumatic memory. The problem is we don't want experts testifying about that because a lot of the experts that we're talking about are not sufficiently credentialed in the neurosciences and all the research surrounding the neurobiology of trauma to explain it. So it's fine to say that victims often remember things in non-chronological order. They often block things out. But to get into that phrase, neurobiology of trauma, may be pushing your expertise a little bit too far. And that's something that we always caution against. Experts need to testify within their area of expertise. If you're an advocate who has seen hundreds of victims, if you have a degree in social work and you're trained in counseling and you're working directly with victims, then talk about that. That's a great type of expertise. You don't have to also be a medical expert or a neurology expert. You're an expert in common victim behaviors, and if you keep the testimony limited to that, that's good for the witness and it's also good for the prosecution, and it's fair to everybody. So expert testimony regarding victim behavior. There are cases in every jurisdiction or statutes or rules of evidence that deal with the myths and misconceptions and the need to counteract them with this type of testimony. I'm going to, when referring to rules of evidence in this webinar, I'm going to refer to the federal rules of evidence. And the first one that's relevant here is Rule 401, which is the relevance rule. And every state has a version of this. But you have to show that the testimony is relevant, and you can do that because there are so many articles out there and cases that show that jurors' beliefs in the myths is just so persistent and so pervasive, and some of the earlier articles that we cited to can help you make that argument to a judge. The subject matter, the common victim behaviors are beyond the ken and understanding of juries. That's so important. That's one of the the factors to be considered whether you can introduce this evidence. And if you don't address these behaviors, if you don't address the inevitable defense arguments based on misunderstandings about victim behaviors, then the jury will not be able to, they won't have a factual basis, they won't have a context to understand the victim behaviors. Is it a proper subject of expert testimony? Well, that phrase, common ken and understanding of the average juror, is contained in Federal Rule 702. The evidence has to be beyond their understanding. It has to be some specialized knowledge that the jurors don't have, and it has to be reliable. The Taylor case really spells this out. Excuse me. It looked at applying the rules of evidence to this subject matter, and this is a 1990 case talking about how cultural myths still affect the common understanding of these cases. This one dealt with a rape case, and even though the effects on rape victims have been studied again for decades, these behaviors are not within the ordinary understanding of the lay juror. When it comes to the reliability of expert witnesses, there are two different standards. There's the FRYE standard and the Daubert standard. They're slightly different, but the truth is these types of expert witnesses, experts in victim behavior, probably should not be subjected to either FRYE or Daubert hearings. There's a great case out of Connecticut, the Borelli case, that really distinguishes between expert testimony to explain common behaviors and other types of expert testimony, such as calling a psychiatrist to examine the defendant and give an opinion about whether the defendant was legally insane at the time the crime was committed. In a case like that, in an insanity case, the expert is really giving an opinion that goes to the ultimate issue in the case, whereas expert testimony regarding common victim behaviors is just more background information. It's basically common information, not specific to the victim in the case, but that applies to all victims, but which jurors generally don't know. And in this opinion, which was very well written and would be great, even if you're not practicing in Connecticut, it's just a great persuasive precedent to show to a judge about why this type of testimony should not be subjected to FRYE and Daubert. When looking at whether evidence is admissible, there are three questions you ask. Is it being offered for a proper purpose? Is it relevant? And is it unfairly prejudicial? Not is it prejudicial, but is it unfairly prejudicial? Because, of course, almost all of the evidence the prosecution seeks to admit is prejudicial to the defendant in some way. That's why it's being admitted. The question, though, is it unfairly prejudicial? In general, there are two types of testimony, right? Fact witnesses and expert witnesses. Fact witnesses can only say what they heard, saw, or did, and expert witnesses can go further, and they can give opinions. And that's what we're talking about here. Opinions supported by literature, supported by training, supported by experience about how victims commonly act. There are two types of testimony. There's direct testimony, direct examination and cross-examination. On direct examination, the goal of the prosecutor or the goal of the person calling the witness is to allow the witness to tell the truth in a convincing manner. When we say convincing manner, what I mean by that is having a witness on the stand who can help move the ball forward, help win the case, who can educate the jury. It goes beyond just getting up there and talking. It's looking at the jury in the eye. It's making sense. It's speaking in plain language the jury can understand. On direct examination, you also want to deflate potential cross-examination. Bring out anything that the defense may try and bring out in cross-examination, but bring it out before the defense has a chance to do that. That goes a long way to sometimes undercutting some of the drama of cross-examination. And always, when you call a witness to the stand, you're laying the foundation for a closing argument. And the closing argument in this case would be to argue that the defense arguments that the victim is not credible because the victim did not act in a certain way, that those defense arguments about credibility don't make sense and are not supported by the facts, because the facts are that most victims don't fight back with violent resistance. The facts are that most abuse victims do not leave relationships or disclose to law enforcement right away. The facts are that most abuse victims endure a great deal of abuse before reaching out to law enforcement and going through this very difficult, very adversarial proceeding of a criminal prosecution. So when the expert when the expert testifies to all these things, the prosecutor then has a strong factual basis to make those arguments in cross-examination. After the witness testifies on direct examination, then it's the opportunity for the other attorney to cross-examine the witness. And the goals of cross-examination are very different from the goals of direct examination. An attorney who's cross-examining a witness wants to elicit favorable testimony. If there's anything that the expert can say that's going to help the defense case, they're going to try and bring that out. They may try to establish that the expert witness has some bias. Does this witness know the victim? Does this witness work closely with the prosecutor's office a great deal? Is the witness being paid for their testimony? Does the witness work for an organization that supports victims exclusively? All of these things might be used to argue by the defense that the witness has a bias. The witness should always tell the truth. If the witness works at a victim service organization, then that's the truth and that's what they should say. The defense may try to attack specific portions of the testimony that they feel are hurting their case, maybe argue that something's implausible or not supported by the research. Sometimes what you'll see on cross-examination is an attorney sort of using a witness almost as a prop to make arguments to the jury, when the questions and answers that are being asked and given are not really as relevant as this sort of show that the defense attorney is making for the jury. That can sometimes be a very effective way of doing cross-examination. And just like the prosecutor, the defense attorney always, through the questions and answers, is laying a foundation for the things that they want to say during their closing argument. Cross-examination is all going to be leading questions. They're going to be questions that suggest answers, whereas direct examination is generally open-ended questions. It's important when being cross-examined to listen carefully to the question. There's nothing wrong with a defense attorney asking a leading question, and sometimes you can answer yes or no. Sometimes you have to explain. But what's important is not to be confused or tricked into saying something that you don't mean just because the questioner was suggesting an answer. You may be questioned about qualifications if you're a witness, or the lack of qualifications. You may be asked questions to show that you're not being truthful, or that you're wavering, or that you're uncertain in some of your answers as a witness. I talked about this a little bit more, but there could be questions about bias or objectivity. The bottom line is that the truth doesn't change depending on who's asking the question. The truth is the truth, and the prosecutor deserves the truth, and the defense attorney deserves the truth as well. When you're asked about qualifications, everything on that CV is relevant, including whether you've published or taught, whether you supervise other people, and whether you have testified before, whether you've been qualified as an expert before. Frequently, the questioning of an expert witness will happen outside the presence of the jury. There will be cross-examination regarding the qualifications and expertise. That will often also happen outside the presence of the jury. And then the judge will make a ruling about whether someone can testify as an expert or not. If the judge qualifies the witness as an expert, frequently these qualifications will be discussed a second time, because the person who's calling the witness wants to show the jury how well qualified they are. So even though the judge made a ruling outside the presence of the jury about qualifications, the prosecutor may want to show the jury how well qualified they are. And as a practice tip to prosecutors, I would strongly suggest that if the judge wants you to do voir dire outside of the presence of the jury, the qualifications of the expert, that you do it again in front of the jury. And sometimes judges want to cut that off just in the interest of saving time, but it's so important when you have a well-qualified expert with lots of experience with lots of different victims, that they be able to hear how well qualified your witness is. When a judge qualifies a witness as an expert, there's a special instruction that is given, and the judge essentially tells the jury that most victims are limited to giving testimony about what they saw or heard or felt, but that expert witnesses are in a different category, and that they're also allowed to give opinions. That instruction doesn't generally exist with other types of witnesses. The expert witness should never try to help one side or the other by shading the truth. You don't want to harm your own credibility. You don't want to harm the reputation of other people in your field that are also doing this type of work. The truth is the truth, and don't do anything that's going to undermine your credibility because it can be disastrous. And once that happens, and there's a set of notes of testimony out there, depending on the community in which you're practicing or the state in which you're practicing, those notes of testimony might be transcribed and sent to the entire defense bar or the other prosecutors, and it really can destroy your reputation and destroy your ability to be an effective expert. Know that the judge and jury are always looking, they're always determining whether to believe someone, determining credibility. They're evaluating the person, even superficial things like what the expert wears are important. So dressing professionally, being objective, looking the jury in the eye and communicating very clearly, precisely, speaking in plain English. If you have to use a technical term, if your expert has to use a technical term, it's so important that those terms be explained. And it's important for prosecutors if someone is using a lot of jargon, whether it's psychology or social science jargon, to make sure that those terms are explained. I always caution witnesses not to volunteer additional information, but to trust the prosecutor and their strategy that if they think you need to explain something or something hasn't been adequately covered, that they'll come back and ask you additional questions. Sometimes we see situations in which experts step beyond their area of expertise and start testifying about areas really that should be covered by other experts, such as medicine, such as the impact of different types of drugs, pharmacology, antidepressants, other types of medications. You see this again and again. I mentioned before neurobiology of trauma. You can do your job effectively. You can educate jurors about common victim behaviors without stepping outside of your area of expertise. Don't try to be a doctor if you're not a doctor. Don't try to be a nurse if you're not a nurse. It's, first of all, an effective defense attorney can really have a field day with an expert who does this. It will not help the case, and it will not help you because, again, it will hurt your credibility in the case in which you're testifying, and perhaps in additional cases later if you try and step outside the limits of your expertise. Sometimes when we're talking about expert testimony regarding victim behavior, we have what we call the danger zone. And the danger zone is getting too close to giving an opinion about whether the crime happened, about whether the victim is telling the truth, about whether statements are reliable. Your job as an expert and your job as a prosecutor calling an expert in these cases is not to elicit testimony or give testimony about this specific victim or this specific perpetrator. It's to give general background information about common victim behaviors that we see in these cases that are very common, that are very well documented in the literature. Stay away from statistics. Stay away from any type of profiling. That's not the job here. The job is to talk about, yes, many victims delay in reporting, and here's why. Yes, many victims stay in abusive relationships, and here's why. Yes, many victims continue to have contact with the offenders, and here's why. Here are some of the reasons. I'm not saying that this victim did it for this reason. I'm saying that this, based on my training and experience, these are the reasons that I've seen. Stay away from the danger zone because it's harmful to the case, and it's also a way to end up with some really bad case law. Where experts are really might be limited. Some of the early case law in this area came out very bad for the prosecution because experts got too close to that danger zone. Frequently, the defense will object to the introduction of this type of testimony. In some jurisdictions, it's done routinely, and judges are used to it, and the defense attorneys don't even bother objecting. In other jurisdictions where it's done less commonly, you're much more likely to draw a defense objection. And we have some responses for those types of objections. One of the objections would be that it's improper testimony because it's just bolstering the witness's credibility. right? Judge, it's improper bolstering. It's not relevant. It violates the rules. But it really doesn't, and we're going to talk about why. Usually the defense will try and make some version of this argument, that the victim's credibility has not even been attacked yet. So why should the prosecution be able to call an expert witness to explain common victim behaviors when the defense has not even attacked the victim's credibility on cross-examination or in closing argument yet? Well, there are several responses to that. First of all, the standard for admission of expert testimony is whether it's relevant and helpful in understanding an issue. And in every one of these cases, victim credibility is the main issue. We're dealing with cases here where the parties know each other in general. We're dealing with cases in which they're not arguing alibi or identification. They're arguing it didn't happen. They're arguing that the victim made the whole thing up. Or in the case of a sexual assault case, they're arguing that there was intercourse, but it was consensual intercourse. So in all of these cases, the victim's credibility will be the primary issue in these cases. And sometimes the victim's behavior may not, the defense may not make the arguments about victim behavior until closing argument. Well, you certainly can't wait until after closing argument to introduce this testimony. It has to come in during the case, and it should come in during the case in chief. When you know that it's going to be attacked, that's the argument to make. Whether you know the defense attorney will make that argument based on the things that the defendant said during the investigation, based on the arguments that the defense attorney made in earlier proceedings, whether it was the preliminary hearing or pretrial motions, you know that the victim credibility will be attacked, and therefore it is going to be relevant. Sometimes the defense will argue that this type of testimony is improperly invading the province of the jury because it's giving some type of expert scientific validity to the allegations. Well, that's not what's happening. What you are doing is countering myths. You may be explaining inconsistencies, but most importantly, you're responding to defense attacks on the victim credibility that are not based on fact, but they're based on myths and misconceptions. And that's what's so important, and that is the response. This is not, again, it's not the type of expert where you have a psychiatrist giving an opinion about insanity, the ultimate trial issue. It's background information, it's educational information, it's common information that is widely known in the field generally about victims. It's not specific to this victim. Sometimes the defense will argue that this is just an improper comment on the truthfulness of a victim, and they're basically all the same arguments. The fact that expert testimony is somehow touching on witness credibility doesn't mean that it's inadmissible. The truth is any corroborating evidence in the case that is going to support the victim's credibility in some way. That does not mean that it's improper. If it's being offered for a proper purpose, the fact that it affects credibility does not bar its admission. And this is really not very different from other types of corroborating evidence and other evidence that will undermine defense arguments that the victim is not credible. Sometimes the defense will argue that you're trying to admit uncharged conduct. This would be especially relevant in a case where you have an expert witness who is going to talk about victim responses to battering, ongoing systematic patterns of abuse and control and violence, and the impact of that battering on a victim. The defense may argue, well, he's only here, the defendant is only charged today with one incident or 2 or 3 incidents, and that this type of testimony is somehow implying that he's committed other crimes that have never been charged. Well, first of all, if there are other acts, it may be appropriate for the prosecutor to file a motion to admit the other acts by filing a motion to introduce other crimes or other acts under Rule 404B, under the Federal Rules of Evidence, or the a similar state rule. Also, if you do have other crimes, it may be important to think about charging those crimes. Do you have a stalking charge that could be filed? Do you have ongoing abuse? Even if you don't have specific dates, sometimes it may be effective to go back and look at all of the abusive behavior, all the battering behavior that falls within the statute of limitations, and make a decision about whether you could charge that. The other thing is that the expert does not necessarily have to talk about specific acts committed by the perpetrator that amount to battering. If they're talking generally about battering and its effects on victims, then that may be an appropriate thing to talk about, while cautioning the jury that the expert does not have any specific information about the battering behavior committed by this perpetrator. That testimony could probably come in with some sort of limiting instruction from the judge if it's appropriate. The jurors are presumed to be able to follow limiting instructions, and not even making the defense make that argument, but writing the instruction and asking the judge to let it come in with an instruction may be an appropriate thing to do in a case like this to undermine some of the defense arguments. So again, we might have to be a little bit creative. But when there is a violent relationship, when there's an ongoing abusive relationship, that will have an effect on the victim, and it may be necessary to talk about that in order for the judge or jury to understand the victim behaviors in the case. Sometimes the defense will argue that there's been no foundation laid for the expert testimony, and the truth is that the only foundation that needs to be laid is that the expert has the requisite knowledge, skill, education, and experience on which to base an opinion, and the facts upon which the expert testifies have already been placed in evidence. So the expert may testify based on their training, based on their experience working with victims, based on journal articles that they have written, based on trainings that they've attended, based on trainings that they've given or articles that they've written. Whatever that is, as long as that has been put in the record, then that is a proper basis upon which an expert should give can give their opinion. The cases talk about facts that are of a puzzling nature. Victim responses to trauma are generally not understood by jurors. They're not understood by lay people. They're not understood by people who don't work in this field. So these facts can be very confusing. They can be very puzzling. And if the expert has knowledge beyond the canon understanding of the average juror, then that is an appropriate, it's an appropriate area for expert testimony. Sometimes the defense will argue that the expert testimony about common victim behaviors is giving a legal conclusion, an improper legal conclusion, almost like a legal opinion. The truth is that that's just not true. Again, it's being offered for a proper purpose, which is to counter myths and misconceptions, and that the expert will not testify as to the accused's guilt or innocence. If they did, then that would be a legal conclusion, but they're not going to do that. And the prosecutors need to make sure that the expert stays away from doing that. They will not talk about whether the victim is telling the truth or lying. They're going to talk about general background information about common victim behaviors. As long as the testimony is presented in the right way, all of the defense objections fall away. But frequently what we see is that the defense objections assume that the witness is going to testify in the danger zone. The defense objections often assume that the expert will give an opinion about this victim's credibility, about the perpetrator's guilt. And to a judge who has not seen this type of testimony before, they may be concerned about that. So it's so important during argument and during the pretrial phase that you make it very clear what this evidence is going to be used for and what it's not going to be used for, so that you get the proper rulings on these cases. The defense may argue that the testimony is speculation. It's mere speculation, Judge. This person doesn't know how victims act. Well, that's a really easy one, because this subject area has been studied. It's been written about. Victims who have, experts who have trained, who have educational background, who have training, who have ongoing training, who are attending national trainings, they're being given this information over and over and over again. We're not talking about giving the victim a diagnosis. We're not talking about profiling the victim or giving the victim some syndrome. We also encourage prosecutors and experts to avoid the area of hypotheticals. Just talk about common victim behaviors and the reasons for those behaviors. In some jurisdictions, it's the custom to present expert witnesses with hypothetical questions so that they can answer in a certain way. And the form of those questions should not be used when it's an expert in common victim behaviors. It's just not appropriate. There are some great resources online, and I don't know if all of these, well, I think the first one may have already been introduced to you during the introductory remarks. It's a monograph on introducing expert testimony to explain victim behavior in sexual and domestic violence cases. And it's available online. You can download the PDF. This document was really written for prosecutors by Jennifer Long, but it's also appropriate for police and experts and anyone who's working in the response to sexual violence. I talked a little bit about the neurobiology of trauma, and there's a great article online from the NIJ written by Rebecca Campbell about the neurobiology of sexual assault. There's great information in there that really does help understand some of the common victim behaviors and the victim responses, especially right after an assault. And at Equitas, we have a page, a library page with a lot of great resources. The resources we have there are for prosecutors, they're for police, they're for advocates, they're for medical professionals, really anyone in the court system, anyone who is working in the response to sexual violence, dating or domestic violence, stalking, elder abuse, and I really encourage you to access some of the materials in there. Again, a lot of it is geared for prosecutors, but not only prosecutors, and there's great information in there. Because we're funded by OVW, all of the work we do, all of our documents are all available for free. So there's never a charge for accessing Equitas or our resources. And the last slide is my contact information. Feel free to reach out to me. If there's anything I can do, send me an email, give me a call. That number goes right to my cell phone. Again, there's never a charge for any of our time at Equitas. And if I can't help you, and if someone else at Equitas can't help you, we have a wonderful network of other national TA providers like the National Clearinghouse for the Defense of Battered Women, PCAR, the Battered Women's Justice Project, and we can usually get some answers within a day or two. That's the conclusion of my presentation. I think we have some time for questions. Sue, can I kick it back to you?
Yes, you can, Chris. Thank you so much. And I have to apologize because when Chris gave us a PowerPoint that had 87 slides, I just couldn't believe he could get through it. And you did, Chris. I don't believe I've ever heard you speak so quickly. But it was great. It was really helpful. So we did have a few questions, and Cindine may have some additional ones. So actually, I'm going to pass it over to Cindine Pizzell. And Cindine is our legal coordinator here at the National Clearinghouse for the Defense of Battered Women, and she's our lead staff on our Expert Witness Project and has had a wonderful set of opportunities to talk with people doing trainings of experts, with people who have utilized experts, and with experts themselves. So Cindine, if you want to ask Chris some questions because he finished exactly on time. I
sure do, and I have to say I am also extremely impressed, not only about the speed, but about the amount of information that Chris just gave us. Chris, we got a question early on when you were kind of going through the litany of myths about victim behavior that come up, and the question was about getting around those myths. So I wanted to ask you, in terms of presenting expert testimony, as a prosecutor, how much time do you spend explaining the fact that these myths even exist? Because obviously people on the jury don't think that they're wrong about stuff.
Yeah. You know, I've never done that. I've never talked to the jurors about myth acceptance or used the word myth. What I do is I talk about there's no one way for a victim to act. And I have an argument I used to make to the jurors. I would say, because it comes up so often, and I would say, you know what, you buy a car and you get an owner's manual. And you buy a VCR and it has a little owner's manual, and you figure out how to set the clock so it doesn't blink 12 o'clock all day. Well, there's no owner's manual that tells someone how to act after they're raped. There's no owner's manual that tells someone how to act when the person they love, who they plan to raise children with and spend the rest of their lives with, turns out to be a violent rapist in their bedroom that they share together. There's no one that knows how to act, and because there is no one way to act, everyone's going to act differently. And so those are the arguments that I make, but I don't talk about myths because you're sort of acknowledging them while dispelling them at the same time. Mm-hmm. So when you have an expert who can talk about these things, I don't ask the expert to mention the word myth or misconceptions. Mm-hmm. We just hit them with the truth and the facts. And then sometimes I will talk about in my argument, in my closing argument, that the defense arguments are not based on fact. The defense arguments that we know the victim's not telling the truth because the victim didn't call the police right away. They're asking you to accept some myth about how this typical quote unquote real victim acts. Well, that's not true. There's no factual basis for that. They're asking you to make a decision in this case not based on the law, not based on the evidence you heard and the facts and the expert opinions you heard from someone who knows about this area. They're asking you to make an opinion about some mistaken idea about how this hypothetical victim should act. That victim doesn't exist. We have a real victim in this case. So those are some of the so to the extent that I mention myths at all, it's really in response to defense arguments. But I generally don't acknowledge that they're out there. And I have to tell you that educating juries about common victim behaviors, it doesn't start with a witness on the stand, and it doesn't start with closing arguments. It starts in the earliest parts of the trial. Frequently during jury selection, we'll ask if any members of the jury either personally or have close friends or family members who have experienced abuse or have experienced sexual violence based on whatever the facts of the case are. And sometimes we'll ask those questions and get those answers at sidebar in private. Sometimes we do it in open court in front of the other jurors, and sometimes the jurors are able to talk about it if it's a friend or maybe a classmate in college. And so we'll ask questions. Well, now you said that you had a friend who told you that they were abused. Did your friend talk to you about that? Did your friend report it to the police? Did your friend stay in the relationship or did they leave the relationship? And by asking those types of questions from under the guise of trying to figure out whether the members of the panel can be fair and impartial, we're also educating the people in the room about common victim behaviors. It's a great way to start the education process. Sometimes ask the person on the jury, do you have any idea why the victim in that case chose you to confide in? Almost acknowledging that act of confiding in someone and disclosing the abuse to a trusted friend is difficult, and that person was chosen very carefully. That later sets the stage to argue how difficult it was for the victim to ultimately report to law enforcement and talk to strangers about what happened to them. So in jury selection, in opening statement, sometimes we want to ask the victim to talk about their behaviors and why they said or did certain things during the assault or after the assault. If you have a cooperative victim, if you have a victim who is well supported, who is in counseling, maybe having counseling specific to sexual trauma or counseling specific to the trauma of domestic violence, they may be able to put words to what they felt, what they experienced, and how they acted in a way that is even more effective than calling an expert witness to do that. So there are some different things we have, different options, different tools we have in the toolkit. In this presentation, we're talking about using experts, but there are some other things we can do, including in appropriate cases, asking the victim to talk about that a little bit.
Well, and Chris, that's actually a really good transition into the next question I was going to ask you, which is because you were just talking about, victims being able to tell their story pretty well in some circumstances. So can you talk about some reasons why you might not want to call an expert in a domestic violence or sexual assault case?
Yeah, that's a really good question. Sometimes victims, sometimes they can't do it. Sometimes they don't want to do it. It depends first on the level of cooperation you're getting from the victim. But even in the case of a cooperative victim, sometimes victims are not able to put words that properly convey what they were feeling and talk about it effectively. Also, sometimes for some victims, it's another level of invasion of their privacy. They've gone through these horrible, traumatic, personal, private crimes. They're now in court and they're talking about it. And for some, they're able to talk about the violence. They're able to talk about what the perpetrator did, but going that next level and talking about the profound impact that the crime had on them, how difficult it was, how it affected them, how the things that they did to cope with the fact that that crime happened can be even more embarrassing and can be even more personal. So it may not be appropriate to do it depending on what the victim is able to do. In the cases in which I've been able to do it, I found it to be extremely powerful testimony. But the reason it's powerful is because it's so difficult for victims. So we have to meet victims where they are, and we have to just be very conscious every step of the way that we're not re-victimizing the victim through the criminal justice system.
Can you, I know that we're kind of getting up to the end here, but can you please talk a little bit about why it isn't appropriate for experts who are giving general testimony on behalf of the prosecution to respond? Well, I mean, it's not like what the expert's doing inappropriate, but hypothetical questions posed by the prosecution to general experts. Can you talk about why that's not appropriate?
Yeah, I mean, in some jurisdictions, experts are required to answer in terms of hypothetical questions. And if the following fact, let me give you it would go something like this. Let me give you a hypothetical question. If the following three things happen, then would that mean, what would that mean to you? Or give an opinion. And the problem is that we're not talking about a specific victim or a specific case. We're talking very generally about educational information about how victims act. So it's really not appropriate. Now, when I say it's not appropriate, I can probably think of some cases where it might work, right? There's an exception to every rule. I mean, maybe the prosecution would say, well, if someone had been beaten and had been enduring ongoing abuse and had also been experiencing economic abuse and had been isolated from their family, how would that, what common behaviors would you expect to see from that victim? That's a little bit of a hypothetical, but it's not the same type of hypothetical that we usually see in expert witness cases. So again, anything that gets too close to setting forth the factors that were present in the case on trial and sort of asking the expert to give an opinion that comes very close to describing why the victim in a particular case did or didn't do something, that's what we have to be careful of, and that's why we recommend not using hypos. Does that make sense?
Yeah.
Okay.
That's really helpful. And okay, I think we have time for one more question. And I see that one just came in from Judy Betterton. Can you talk about other behaviors that you've seen expert testimony address besides the ones that you mentioned, or do you feel like that was pretty comprehensive?
Subsequent sexual contact with the offender is a big one. Subsequent consensual sex after a sexual assault a victim going back to their husband or boyfriend or partner and having consensual sex after being raped is a very common behavior. Someone has just had forced sex, they have had their body taken from them, and in an attempt to make their life normal again and to take control back over their body, having loving, mutual, consensual sex is something that I've seen many, many times, and it's something that defense attorneys sometimes will have a field day with. A victim who washes themselves after being sexually assaulted, very, very common. And the defense will say, oh, they were just trying to get rid of evidence or those types of things. Boy, oh boy. In domestic violence cases, all the different versions of staying with an abuser, not leaving an abuser, concealing the abuse, keep affirmatively lying about abuse to keep other people from knowing, putting on makeup or staying away from work so other people would not be able to detect the abuse, all very, very common behaviors in these types of cases.
Thank you. Very helpful.
You're welcome.
Sue, can I kick it back to you? Maybe
Sure.
not.
Thank you,
Great.
Sandine. As Sandine said, Chris, that was an amazing amount of really great information. Wow.
Thank you.
It was really, really helpful and a lot of food for thought. So I really want to thank you very sincerely and profoundly for doing that and doing that so well and doing that so quickly and really touching on so many important issues, and it was just great. So thank you. And I really want to thank all of our participants as well. And unfortunately, there were some technical problems, and we lost some of the chat. It just disappeared. So, Chris, we don't have all of it, but we have some of it that we'll be able to share with you. And Sandine, before we kick it back to Chris to see if he has any final words, is there anything else you'd like to add?
No, just that, even though I've kind of cornered Chris over the telephone to ask him a million questions in the past, I have to say I learned at least 10 new things today, and I'm just really grateful for that opportunity.
And we trust that the participants did as well. So Thank you, Chris. Chris, do you have any final words that you want to share with the group?
No, thank you to you. Thank you for the participants, and thanks to everyone for the work that you're doing. Keep it up.
Okay, thank you. Okay, I'm going to be hanging up the phone. I'm going to leave this chat on, so if you want to say really nice things about Chris, you can do so, and we will share that with him. I'll leave that up for just a couple minutes, okay? So thank you. Talk to you soon.
Thanks, Sue.
Bye.
Bye-bye.